I and two of my colleagues, Adell, Amos, and thank you for joining us today. I and two of my colleagues, Adell, Amos, and Greg Dotson, are going to talk about a recent case called Loper Bright versus Raimondo. Before jumping into it, we generally want to recognize our distinguished guests when they arrive, and I want to note that we have among us District Court Judge Ann Aiken. Welcome, and thank you for being here. We're going to spend the next 45 minutes or so talking about this case that came out only 10 weeks or so ago, 10 weeks today. We are going to hear from both Adell, Amos, and Greg Dotson. Before jumping into it, I will introduce both of them. Starting with Adell, Clayton Hess professor here at U of O Law, also executive director for the U of O Environment Institute. After practicing with the Department of Interior for a while, she started teaching. She joined the faculty here at U of O Law in 2005. I have it on especially good authority that her finest year teaching was 2006, when I was a student of hers in civil procedure. And it's a topic near and dear to my heart. She, in 2008, took a leave from teaching to join the Obama administration as Deputy Solicitor for Land and Water Resources, again at DOI. Got her bachelor's from Drury and JD here at U of O Law. To her right and my left is Greg Dotson, also faculty member here and with Oregon Law's Environment and National Resources Law Center. Before joining U of O in 2017, served as Vice President of Energy Policy for the Center for American Progress in DC, before which he held senior environmental staff positions at both the House and Senate. Also served as Chief Counsel for the U.S. Senate Committee on Environment and Public Works, and graduated from Virginia Tech and also U of O Law.
Go Ducks.
Go Ducks, for sure. It's all three of us. I, by trade, am a lawyer here in town. I moonlight as an instructor, and the class that I teach is called Oregon Practice and Procedure, focuses on the rules of civil procedure and how they kind of play out on the ground in state court in litigation. One of the things that I like to do in the first class, just for like 15 minutes or so, is go through a rehash of just Civics 101. Talk about the structure of our government. I won't do that today, but I always notice every year there is an aha moment among the students when you talk about what is the executive branch. Because students just like us talk about the presidency. And of course that's right, but really the executive branch is mostly made up of dozens and dozens of administrative agencies whose job it is to carry out the law. And those are really the parts of the government that touch our everyday lives. FAA's oversight of airlines, the FCC's oversight of broadcast, the FDA's oversight of drug applications, and so on and so forth and so on. All of this is just by way of kind of table setting for what it is we're talking about in Loper Bright to make sure that we're all kind of in the same context. The law that governs all of those agencies, the APA, the Administrative Procedure Act, has one particular provision that I'm sure both Greg and Adell have memorized. The key is that when agencies' actions challenge, the courts must defer to agencies unless their actions are, quote, arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. It's that last clause that I think is especially tricky, at least for our purposes today. And one of the reasons is not just because federal statutes themselves are often ambiguous or incomplete, but because it is the nature of the statutes that govern our administrative agencies specifically that are kind of uniquely incomplete because the Congress has to write these things at kind of a high level of generality. And the example that I give students all the time is state law requires that you have to take a driving test to get a license to drive, but you can be sure that legislators are not writing the questions on that exam. They can't they can't write laws in that kind of fine-grained detail, particularly when you're talking about laws governing administrative agencies, right? The law is not going to decide when you take the test or how often or how many times you can take it, so on and so forth. That is the job of the agency there, the DMV. And so it's sort of the nature of these laws to be incomplete. You'd be surprised at how few of those things are actually specified by the statutes. And so the way I see it, there are kind of three principles that guide the conversation that we're having. First, the administrative agencies are tasked with carrying out federal laws. Second, in order to do that, they have to first figure out what those laws mean in the first instance. And third, often those laws aren't very clear or aren't very specific or might be incomplete in some way, and yet the agency has to act anyway. It's got to do something. And so that opens up the question, what do we do? How do we know when they're wrong? How do we know when they have acted otherwise not in accordance with the law? For most of the last 80 years or so, the kind of going assumption has been that when we're talking about statutes that govern administrative agencies, or when there's a law that tasks an agency with doing something, that agency probably has some important expertise in that subject matter, right? FCC probably knows a lot about radio broadcast. The FAA probably knows a lot about airplanes. IRS knows a lot about taxes. And so that is expertise that the courts generally don't have. And so courts ought to give some special weight to what that agency thinks the law is intended to mean. And that was kind of the status quo for most of the last 70 years. In 1984, that approach was made much more concrete in a case called Chevron versus NRDC, the National Resources Defense Council. This case concerned a particular law that's actually, I think, a really good example of these incomplete statutes that govern our agencies. And in this law, it was, this had to do with pollution. The law regulated the amount of pollution that can be emitted from a stationary source. But what's a stationary source? Is it a warehouse? Is it a factory? Is it a part of the factory? Is it a smokestack? Is it a bundle of smokestacks? Is it a machine in the factory? Is it a pipe coming out of the machine, right? This is all unclear, at least on the face of the law, and so in that case, the agency, in the first instance, had to figure out what it was that stationary source meant. They decided, we're gonna consider a facility a stationary source, and that was that. Went up to the US Supreme Court, and they said, well, we can't tell whether it was intentional on Congress's part to leave that unspecified. But as long as the agency's construction of that term is reasonable, we're going to defer to the agency's interpretation. That is, we're not going to second guess them. We're going to presume that they're correct in interpreting that statute. And so that kind of firmed up what had been the general approach by federal courts in decades before that. And so, of course, we call that Chevron deference because it comes from Chevron versus NRDC. That was the universe that all of the federal administrative agencies kind of operated in for the last several decades until 10 weeks ago. Enter Loper-Bright, case involving all 9 justices. 6-3 majority led by Chief Justice Roberts formally ended Chevron deference, and that's what we're going to talk about today. It almost doesn't matter what the case was really about, but I'll mention it anyway. It had to do with so the Department of Commerce oversees the National Marine Fisheries Service, and they were imposing fees on certain fishery operations in order to fund a fishery management plan, and the fisheries didn't want to pay it. But it kind of doesn't matter what it was about. What matters in that case was whether the court was going to take that same approach that was described in Chevron or not. In short, the opinion said, The APA doesn't say anything about deferring to agencies' interpretations of laws. Interpreting laws is our job as courts. That's what we do. That's the whole point of being a judge. We interpret the laws. You can't do that, we can. In so many words, they didn't quite say that. But the court's reasoning focused on the language of the APA, which instructs the reviewing court should decide all relevant questions of law and interpret statutory provisions. It doesn't say anything about the agency doing that. And the court kind of rejected this central idea in Chevron that Congress generally intends agencies to fill in the gaps. They said that's not really a fair assumption to make. And so what makes Loper-Bright so remarkable and I think so worth talking about today is before this case 10 weeks ago, when an agency carried out a law by adopting some new regulation or decision, as long as the underlying legal interpretation of the statute was reasonable, then it'll withstand legal challenge. It will stand. And therefore can be relied on by you and by me and by other agencies and by the companies who are regulated and by other individuals. We can rely on these things as probably staying put, at least until the agency changes its mind. That's much less certain now, because after Loper-Bright, the courts have a much greater power to say that an agency's interpretation of the law, even if reasonable and even if relied on for decades, was nevertheless incorrect and has to be reversed. So in short, there's just a lot more uncertainty and I think unpredictability in the world of administrative law. To talk more about that uncertainty and what it means for agencies, what it means for Congress, and what it means for the courts, I'll hand it to both of you. And then after you guys have your sort of introductory remarks, I'll have some questions for them that they can answer both.
Terrific. Well, I'm Greg Dotson. I'll go ahead and get started. I think that was a terrific introduction. Thank you, Aaron, for that. It's hard to overstate how important Chevron has been in environmental litigation over the years. Just to give you a few reference points, there was a study in 2017 that found, it looked at 1,300 Court of Appeals cases from 2003 to 2013, and they found that Chevron had overall, well, I'm sorry, backing up, Chevron has been decided over 18,000 times in cases. So it's a bedrock decision. Looking at 1,300 Court of Appeals cases, they found that that on average, courts of appeals applied Chevron in close to 3/4 of cases addressing agency interpretations. And agencies prevailed when Chevron was applied about agencies prevailed when Chevron was applied about 77.4% of the time. When Chevron was not applied by the court, agencies prevailed about 38.5% of the time. So is that a reflection of courts not wanting to defer? Is it a reflection of Chevron? I think regardless of how you interpret that, Chevron has been very important in the way courts have reviewed agency actions over the years. There was also a 2018 survey of appellate judges, and what that generally found that judges felt that they were bound by Chevron, but they didn't like the Chevron framework, and so they're now freed from that. I think looking at this case, it's important to distinguish Chevron the case versus Chevron the doctrine. Chevron the case, as Aaron mentioned, was rooted in, it was a Clean Air Act case, and Congress provided Clean Air Act with its own judicial review provisions. It's not an Administrative Procedures Act statute. And so it's just, I was immediately scratching my head when Loper-Bright came out. Chevron is overruled, and there is a discussion about the inherent role of courts, but primarily it's based upon a statutory interpretation of the Administrative Procedures Act. You know, evidence number one is the APA says the reviewing court shall decide all relevant questions of law. Well, that doesn't apply to Chevron because Chevron wasn't that. And I think that's really goes to the Chevron as a doctrine, which grew through the years, through the decades, cited 18,000 times in these cases. And my question was just resolved 2 days ago with the first decision out of the DC Circuit Court of Appeals, that U.S. Sugar Corporation versus EPA, in which they were challenging an EPA rule regarding pollution controls for biomass incinerators, boilers. And the court basically looked at the facts. They said this is a Clean Air Act case. APA doesn't apply, but you know what? The reviews are essentially similar, so we're going to apply Loper Bright. And I have a feeling that that's kind of going to be a little bit of, just as Chevron sort of bleeded over into other areas, I imagine Loper Bright will also bleed into other areas beyond the APA. That's my hunch. In the U.S. Sugar Corporation versus EPA case, you had a situation, very complicated procedural case under the Clean Air Act, in which EPA had originally proposed boiler standards for a whole large category and subcategory of boilers in 2010. And the Clean Air Act has an approach that says we're going to bind people to standards when they're proposed, not when they're finalized. And that way people can't exploit the time between a proposal of a standard and a finalization, right? You're held to the proposal, and that way you can't rush a project and escape more stringent regulation. Well, there was litigation. It was very complicated. They ended up having to resolve some litigation, propose a new standard for a small subset of those originally proposed in 2010 in 2022. And so the bottom line of that rule was any facility that was built after 2010 was considered a new facility under the 2022 proposal that no one had ever seen. And if that sounds absurd to you, I think the court found it was absurd. They said we're going to use Loper Bright and not defer to the agency. We're going to determine what our best interpretation of new source means. And they told EPA to go back to the drawing board on it. For me, I look at the facts of that case and I say, is that materially different than Chevron? Would a court have looked at that and said, that's an unreasonable interpretation of the statute? I think they could have. And so I think the first point I really wanted to hit here is there's a robust conversation in the academy about just how important Loper Bright is. Does it fundamentally change the kinds of decisions that courts will reach as they examine these rulemakings? And I don't think we know that for sure yet. I do think, and we'll talk about this more in a moment, when you bring in the other decision, corner post of this same session, a lot of people didn't pay as much attention to that decision because it came out the same day as the presidential immunity case. But you put that case with Loper Bright, and it's much more serious. And we'll get to that in a moment. Is that an okay place to start?
Yeah, that's great. Hi, it's nice to see you all, especially former students. It's really great. I see you out there. My goodness, the APA and Chevron. I've spent a lot of time with the APA, and I teach administrative law. And I think in terms of opening remarks, what I just want to offer is that Greg is accurate that I think everybody's trying to figure out what the impact of Loper Bright truly is. And I was listening to another commentator recently who said, you know, when Chevron came out, it didn't make the news. You know, it was just a case. It was a really specific Clean Air Act case. It was subsequently what the lower court started to do with Chevron and how Chevron was cited, and as the doctrine emerged, that it grew into its significance. And so we are in this era. I get asked all the time. I was just asked in the context of the Oregon Administrative Law group, state bar group, what does Chevron mean? And we actually, or what does Loper Bright mean? And we don't know yet. We right now, as of today, based on the research that Greg and I did, have 2 circuit court cases that are citing to it. One of them throws out an agency decision. One of them upholds an agency decision, both citing to Loper Bright, right? So it's tied right now in terms of, we're at a tie. The game goes on, we're at a tie in terms of what happens. So I think everyone's watching really closely these cases as they come out. And so I thought what might be valuable as we start talking today is just, and I am an admin law teacher, I don't teach Civ Pro anymore, I teach admin law, is to just think about this administrative law context for a minute. And when I teach admin law, you know, I really emphasize the separation of powers part of administrative law. What's really going on here, I think, in administrative law is this conversation between, you know, a conversation that the courts are leading in their case law about how the 3 branches of government are going to relate to one another. And I think what's so alarming, I'm curious what our next group of panelists will talk about in this context is, it seems like a pretty significant power grab by the courts that really changes the dynamic of who is saying what the details of the law are. But as my mentor and now friend Mike Axline told me when I first wanted to write a law review article on the deference doctrine, and how I was a disliker of Chevron at that point, right? He said, you know, one's view of deference is deeply contextual. Because you will find folks anyone who sues the government, regulated industry folks or environmentalists, have gotten frustrated by Chevron and the fact that the court felt the need to defer, right? And so this landscape around which branch of government was going to say what things like stationary source meant under the Clean Air Act, or what endangered or jeopardized means under the Endangered Species Act, or what waters of the United States means under the Clean Water Act, right? The question of who got a say in that, you know, well, depending on what judge you're in front of, or depending who's in charge of the executive branch, if you have substantive views, you may feel like you've got an advantage in that context. And that was the playing field. So there's this, we're in this moment, I think, post-Loper Bright, where, you know, plenty of folks, and on many days I agree with them. I think as we were prepping for this panel, I was in this bucket, you know, of like describing sort of this onslaught of litigation, all this upheaval, that the court was really irresponsible in doing this, because there are hundreds and thousands of administrative law decisions that are made every day that just kind of keep things working, right? And it's at a level of detail that you would never imagine Congress would carry out, or that the courts had the level of expertise in this context to carry out, right? And so it's just like you've just upended all the apples. You've just dumped all the apples out of the apple cart without a ton of guidance about what to do. That's why everybody's asking the question about what this landscape looks like. And then there's a sort of a little bit more moderated, and all the commentators are back and forth, which is maybe it's not the end of the world. There was courts were deferring to the expertise of agencies before the Chevron decision was decided. It was called Skidmore deference, and courts deferred and didn't defer to what agencies were doing. When I teach this content, I was telling this to Greg earlier, and a lot of US DOJ attorneys talk about this, it's the vibe test. I know US DOJ litigators who are like, I can tell by the first two questions that a district court judge asks me, I will not make eye contact with Judge Aiken sitting over there, if we're getting ready to defer, if we're in a situation where the court is prepared to defer or not defer, and it may or may not have anything to do with Chevron. If they're gonna defer, they'll cite Chevron. If they're not gonna defer, they actually may still cite Chevron, but I'm gonna get kicked out on step 1, if you're familiar with Chevron. Or I'm gonna get kicked out of step 0 that emerged under Chevron, right? And so it was a vibe. I would tell my students, when you read an admin law case, pay attention to the first few sentences and make a guess in the margin about whether the court's going to defer or not defer. See if you can start to feel the vibe, right? Because a lot can be justified. And particularly since 2016, there were a lot of empirical studies that were coming out that were showing that, Chevron deference had been really inconsistently applied. It was hard to find a pattern. And also, the concept of the Chevron bleed, Greg referred to it, that Chevron was this like really specific case under the Clean Air Act. Then it became a case about Section 706, 2C of, the standard of review for how courts, what standard of review courts will apply when they hear one of these cases. And it was only in a rulemaking context, and then it sort of bled over into the informal adjudication context, and then it bled into other places. It became this dynamic. So we don't know that answer. There is a decision also out of the Seventh Circuit now that involves a Consumer Financial Protection Bureau regulation. And in that case, citing to Loper Bright, they uphold the agency's defining of what an applicant is for this particular credit card decision, or this credit card rule. So like I opened with, we're at a tie now. We don't know, but it really does change the dynamic. And I think we'll talk when we get into some of the questions I think Aaron has for us about what some of the risks and dynamics are in the post-Loper Bright era. Yeah.
So the first question that I had, sort of keying off one of the things that you said, I think often there will be a distinction between what an agency thinks Congress probably meant in a law and what they think or expect today's Supreme Court will say Congress meant. And sometimes there's a divergence between those two, and I think that sets up an agency to take either of two paths. Either they're going to interpret this law in the way that they think Congress intended it, or in the hope of more durable, lasting action, interpret it in the way that they think the court will interpret it. Do you see agencies having to wrestle with that decision post-Loper Bright, or is that sort of same old, same old?
I guess I would answer that question by saying, I think over the years we've tended to use Chevron as kind of a catch-all for understanding that agencies have expertise. Instead of the limited explanation of the case, which is you have an ambiguous term, is the agency interpretation reasonable or not? Don Goodson at NYU makes a good point about this, that discretion is different than deference. And when Congress gives an agency discretion, it is different than deference, and it shouldn't. I think there'll be an effort by the agencies to reinforce that difference going forward, and saying this is not a Loper Bright question. This is a question that's contemplated in Loper Bright, where Congress wanted us to fill in the details of a program. They said, here's something that it's not an ambiguity, but it is a policy, it's a goal. It's something that necessarily has some complexities that Congress can't deal with.
So it sounds to me like, if I understand your answer right, it may cause agencies to sort of characterize their decision less as being a matter of statutory interpretation and more as being a function of the powers that they expressly do have or have been delegated from Congress.
I think that's right. There's a D.C. Circuit case about the Federal Power Act, and there Congress told the Federal Energy Regulatory Commission that rates have to be just and reasonable. And the court starts off by saying, well, Chevron says that they should be able to interpret this, but just and reasonable is not a question of ambiguity. It is a question of judgment. It's charging the commission to do the necessary fact-finding to determine whether or not. And that's something, when you read Loper Bright, the court clearly contemplates that there are going to be moments in which Congress has asked the agency to fill in the blanks, to use their judgment in ways that are explicit, and it's not an ambiguity of a term. And so I think the courts agencies are going to do just as you're saying, trying to figure out how to draw that line in a more concrete way to try to insulate them from these kinds of challenges.
Yeah, I think that's exactly right, and I think we'll see really specific exploration of unique and concrete statutory terms. Agencies are creatures of congressional authority. The agencies don't exist until they are made to exist. And so I think you'll see these really, which may mean that each of these early Loper Bright cases only is relevant in the context of this language in the Truth in Lending Act for the Consumer Financial Protection Bureau. It's not going to say something broader to us about the separation of powers balance that has been upset here, right? Agencies will get really rooted, I think, in their authorities and the specifics of their statute, and so when their challenges come, they'll be very tied to the particular statutory language. I do think there's this, we're anticipating, I think, that for agencies that are given direction like promulgate all needful regulations to carry out this statute, right? With a very short, non-detailed kind of authorization. I think agencies are going to be increasingly nervous, and we can talk about whether we think it's a benefit or not a benefit for agencies to be nervous about issuing regulations in order to provide clarity so that we can move forward. There are arguments on all sides of that, but there are plenty of agencies, and if you look at the Seventh Circuit case on the Consumer Financial Protection Bureau, it's a long paragraph of statutory language that Congress directs the CFPB to carry out particular things, and it has a lot of detail in it. It would be hard to imagine there that Congress was asking the court to do that task, right? That Congress is actually asking the agency. And of course, the court can also now, it can still cite to Skidmore and say, we're gonna give respect to that agency interpretation, right? So,
keying off of one of the things that Greg, you said, and I think Adell was in your answer too, you know, when you have a law that uses language that seems delegation-like, I think you used the word judgment. You know, well, in whose judgment? We're assuming that it's in the agency's judgment. One of the things that Chief Justice Roberts said in his opinion was we can't just assume that Congress intended a delegation of that kind of decision-making power unless it says so. Is it reasonable to expect Congress to do that? Or is that just wishful thinking? Or should we expect more of that from, what do you think about that?
Well, I think that there's a lot of examples in environmental laws of where Congress has said in the judgment of the administrator or as determined by the administrator. And so, but it's not going to be in every case. When this came out, I saw someone had written something, oh, this means that greenhouse gases won't be regulated under the Clean Air Act anymore. And I completely disagree with that for a number of reasons. But one of them is that, you know, you do have that express grant of judgment to the administrator to make decisions. So so I think we have a number of those kinds of sort of express delegations already throughout the environmental laws. I think it's going to be hard for Congress. I mean, having worked in Congress, I think now that there's really the importance of that language is highlighted in this case, it'll be even harder for it to be put into new statutes because there would just be a fundamental disagreement about whether they want to provide that kind of express authority.
About who should have the authority.
Who should have the authority. I can recall one negotiation about this precise matter, in fact. So it's going to be harder, I think, in Congress.
I found a quote from person who works in the context of higher ed regulations, and it is that it is laughable that Congress will become a model of efficient, detail-oriented legislation. I don't know if it's laughable, but you know, I think there have absolutely been times, and Greg, you probably know that with a lot of specificity, where you know you use a word in the statute, and the statute is passed, and each side is like, may have a different sense of what that word means. And you would have never gotten that statute passed had you had to wrestle to the ground what that word meant or who had the authorities, right? And so it's a draw. You pass the statute, you move on, and it plays out in the administrative, you know, process. So I hope that Congress is able to provide the kind of specificity, but you were showing me an example from just this morning where there's some language that actually cuts the other direction, right? That is trying to maybe limit that. This is the thing about Loper, right? The court's getting to say what the law is works for judges who might more expansively interpret laws that you like. This is the deeply contextual part, right? The one we were talking about was, you know, NEPA, the National Environmental Policy Act, is often it's thought of as just a procedural statute. Well, NEPA has some language in it that's super substantive. And after Loper, right, if we're not deferring to CEQ's interpretation of that anymore, couldn't a judge that was so inclined say what the law is and turn NEPA into a very substantive statute as opposed to a procedural one, right? So it can cut empowering that branch of government, you know, could cut in multiple ways. Now, if all those cases end up in this Supreme Court, then we know how it cuts, right? But how many decisions cite Chevron? 18,000? I don't know if they're going to be able to hear them all. They're going to have a busy docket. You know, the federal courts are potentially going to be flooded for reasons, and we should get to corner post.
It's a good time to become an administrative lawyer for any students out there.
It's an
important time.
Yeah, it's an important time. There is not a major law firm in the country right now, or not any that I have checked, that doesn't have a article up about Loper Bright, that doesn't close with encouraging clients to seek them out, to issue a new challenge to an administrative regulation. Greg referenced this earlier. There's actually this corner post decision, which is another decision that kind of got overlooked because of the presidential immunity case, that changes the way you calculate the statute of limitations for challenging an agency rule. And it opens up the floodgates. I don't know if you want to say a little bit more about
I'm happy to. The corner post, basically, the Administrative Procedures Act has a 6-year statute of limitation, and it talks about the date of accrual in a way that it was sort of open to interpretation. And it's always been interpreted as the date of the final agency action, which won't surprise anyone in the room. Corner post says, no, that 6-year statute of limitation begins to run upon the date of the injury. And so, the facts of the case had to do, I think, with a credit card company that was actually created after a rule had been finalized in order to challenge a rule. So what this potentially does in the APA setting is it means go out and find an injury, and you can challenge a rule promulgated pursuant to the APA that was finalized in the 70s or 80s. Or
way past the time that you would ordinarily be able to.
Whenever you want to. Now that is not the last word from the environment, because a lot of the environmental statutes don't rely on the Administrative Procedures Act. They have their own judicial review provisions, and they also have their own jurisdiction stripping provisions. And so Clean Air Act, Clean Water Act, CERCLA, RCRA, they all say that courts are stripped of jurisdiction if a petition isn't filed within 60 days of the date the action appears in the Federal Register. So I think that corner post is not going to apply to those environmental laws, but there's a lot of laws that will apply to, and that's going to be a lot of litigation. And I think you combine that with the fact, we said, well, you go through the substantive process of Chevron or Loper Bright. You're not sure where you come out, but I think there's this overarching aspect to this, which is what the Supreme Court has said in Loper Bright is, judges, you don't need to defer to agencies anymore. Don't worry about agency expertise. And I think that is a hunting season is open, basically.
This wasn't on my list, but your answer causes me to wonder, for either of you, are there particular provisions or particular aspects, like, especially in environmental law, that you think are the sort of low-hanging fruit or very clearly in the sights? I'm not laying out that litigation strategy. Things that you think are very clearly in the sights, and you said it's hunting season.
Yeah, I mean,
I'm
not telling anyone anything that they haven't thought of. But I mean, like an obvious one that I worry about is a lot of the client progress that we're going to make under the Inflation Reduction Act has to do with tax provisions, and many of those tax provisions had to be implemented by regulations which were issued pursuant to the Administrative Procedures Act. So you have, for example, hydrogen tax credits, which they're doing a lot of work under the term of
it really wants us to have
Anyway, there's terms in there that I wonder about whether people will try to exploit that. I think that's already we're already starting to see some of that happen.
I mean, I think all kinds of things. The word jeopardy in the Endangered Species Act is defined in regulation. Now, it's been consistent and well-defined for many, many years. But now if someone their development can't move forward, or there's a biological opinion that's released, and it's new, we're well past the 6-year statute of limitations, is that going to give them, an action? Now, the ESA may have some statutory language, as Greg said, that pushes back on that tolling of that statutory time period. But I anticipate we are gonna litigate all of this. The federal courts, I'm really curious to see, like, the studies of the number of administrative law and docket cases. I mean, the federal court, this is a part of this that feels really irresponsible to me on the part of the court, just in terms of the management of that caseload in the federal court system, right? I don't know how the federal courts aren't gonna be flooded with new challenges based on LOPR. It's the industry du jour, you know? Go look at all these law firm websites. I mean, people are imagining that they're going to make a lot of money doing post-local right cases against the federal government. So people are imagining that is in their future, I think, now. So.
That's kind of a funny part about Loper Bright. If you read it, it says, well, application of Chevron is so Byzantine and complicated, we just need to go to something simple like this. And they don't tell you exactly what this is, except that Chevron no longer applies. And so I think the many years that we've used to sort out agency deference is now we're going to repeat that in the context of Loper Bright.
Well, also one of the things that Chief Justice Roberts said in that case is we're still going to give due respect to agency decisions. And if you look back to the pre-Chevron decisions like Skidmore, one of the things they talk about is, you know, if the agency can convince us not only that it's right, but that it's been this way for a really long time and let's not upset the apple cart, that is due to, you know, that is due some weight. Is all that just lip service now, or is that, are you hopeful that like Adell in the example that you were talking about, where a term has been interpreted in the same way for 40 years, will the agency still have a pretty solid toehold to say, come on, it's been this way for 40 years, it's presumptively correct?
Don't you think that's going to be part of litigation strategy about which federal judge to get your case in front of?
There you go.
To upset settled expectations. I think there are particular districts that people know to file lawsuits in. I mean, I don't know. I want to be cynical. I'm working really hard to not be cynical. But people don't, you know, but it opens it up. Isn't, you know, there's just, yeah, I think. I hope things like, you know, the sort of regular course of business and what we've come to rely on, even though all of us can pick, all of us know a case where the court deferred to the agency and it made us mad, right? And we wish they hadn't, and we think that was wrong. But what does it mean to live in a world where we lose, I don't know, I'm done being mad about that. I'd just rather be in a world that has some predictability to it. And I worry writ large that in the context of just where we're at in the arc of American democracy, to go here, is just that, you know, we're gonna break it. We're gonna break the system. You know, can the system hold up under this kind of, you know, upheaval? Hopefully not. We're tied right now. We're at 50-50. Maybe the landscape won't change that much. But it creates the possibility for it. And it's really when you read, if you read Loper right just on its face, it's not that, you know, you can sort of imagine it narrow and constrained. It's when you put it in the context of the Sackett decision, you know, last year, the West Virginia versus EPA, inventing the major questions doctrine, the corner post decision, upending the statute of limitations, eliminating the right to an abortion, the Roe v. it's upending. It's just this. It's an activist court, in my judgment, right? It's and so that's consolidating power in that branch of government.
Loper Bright explicitly has a section that says we're going to leave all existing decisions based on Chevron in place. We're not disrupting them with this case. And then
wink, wink.
And then a couple weeks later they do corner post. And so I have a hard time understanding how to read all those things together.
So all of this is consistent. I think we're right. So we're at 2:40. I'll ask one last question on my part. Your responses from the last several minutes are consistent with what I've heard from practitioners and academics alike, which is worried. Mm-hmm. But is there anything in this decision that causes you to be hopeful or optimistic about the future of AdMemo? Or the court in particular?
And the only thing I would really say about that is that Gorsuch's concurrence. One, to make this a constitutionally rooted provision, so that it's not simply based on the Administrative Procedures Act, where Congress could intervene and decide where judgment should be provided, where authority and discretion should be provided to agencies, but instead make it something deeply rooted in the Constitution, which would be obviously very hard, if not impossible, to change.
You're talking about a decision that isn't just rooted in what the APA allows, but more, what do we think agencies are? And
what does the
at what
Constitution
point
think agencies
do
are?
right, at what point do they start to tread on a separation of powers problem? You're doing what the judiciary should do, or you're doing what Congress should do.
So I thought that's an important limiting feature of the decision.
I think it gives us an opportunity to look at how the separation of powers worked between the three branches of government with the existence of administrative agencies prior to the Chevron decision, and to look back and seek guidance from, a case like Skidmore, to look at this context. And it may give us the opportunity, bureaucrats and agencies take a lot of guff. Nobody likes a bureaucrat, right? But they were my clients for a very long time. They're very committed. My students who've had me have heard this diatribe. They're committed public servants who are trying to carry out a mission. They view themselves as working on behalf of the public. They don't always get it right. But, I wonder if we're going to enter an era watching the courts that want to revisit this stuff muck around in these really scientific and technical areas where they don't have expertise and they don't know what they're talking about. No offense to judges in the room, but you can't know everything about everything, and if we will see sort of a recognition that expertise is a valuable thing.
Sort of a pullback.
That there is something happening there that feels of value to us as a society. And I think this constitutional question that Greg raises, it's the executive branch. It's a vision of, the agencies are created by Congress, but it's really, what is the role of the executive branch? And this conversation we're having about where that power sits among those three is a really serious one. And this makes it more serious, but maybe we need to be more serious about that conversation. So.
Good place to stop. I think
so I'm going to start with, this has already brought in a number of questions. We're going to start with one online question and then go around the room. So do you think Loper's overturning of Chevron will trickle down to the state supreme interpretations of their own APAs, many of which are based on 1946-1961 law? We've seen more justices on more state Supreme Courts, though not in Oregon, embrace the robust state constitutional non-delegation doctrine in the last few years. To the extent that non-delegation concerns underlay at least Gorsuch's concurrence in Loper, it seems like there could be a similar movement at the state level.
Yes. Loper Bright doesn't bind the state of Oregon or any state, but in each state, you have the same separation of powers dynamic and the same issue at play in terms of how the courts will treat the expert judgment of an agency. So we can do this 50 times. You can do this at the federal level, and we can do it 50 times in each of the states.
I think Greg touched on it when he referenced Justice Gorsuch's concurrence. I haven't read Loper Bright. But if Congress tried to codify Chevron, would that violate the constitutional separation of powers? Because Congress could do it either by amending a specific statute like the Clean Air Act, or by amending a global statute like the APA, for example.
Justice Thomas would say so.
Yeah.
I think that theoretically Congress could do that. I think those sorts of generally applicable rules of interpretation are just really, really difficult to get through Congress, and I personally have a hard time holding out a lot of hope for that outcome, but I think it's possible.
Any more in the room, because there are some online. Okay, I'll go back to one of our online questions. So, do you foresee courts turning more frequently to court-appointed experts for their understanding of complex cases, or will they rely on those expert views presented by the parties?
I think there's been, I don't have the numbers in front of me, but I think there's been a pretty, almost an exponential growth in amicus briefs to bring in expert views. And some of those are parties that are, may not actually be parties in the case, but they're very much allied with one side or the other. And that would feed into exactly the dynamic that's being discussed here. Whether that, I guess I could see that growing if everything is going to be reviewed almost on a de novo basis. Courts might be more interested in that because they wouldn't be deferring as much. What do you think, Adell?
Well, I think, there's some interesting academic literature out there about, just the deference doctrine in general and how it on questions of fact, where Chevron has bled into the, not just the interpretation of ambiguous terms, but Chevron also bleeds into the conclusions and findings that agencies make, which are often conclusions and findings about particular facts. There have been these comparisons that have been made about how this deferential standard of review sort of sits in contrast to what would happen in a civil litigation context, where you'd be using, the evidentiary rules and the court would be the trier of fact, or the jury would be the trier of fact, and you would be, the different sides would present that evidence. So, we could see as courts face not relying on the expert opinions of the agencies, the need potentially to create this kind of context where you're trying all of these facts like you would in a civil context, rather than relying on the expertise that the agency has used. I'm not a judge, but that seems very time consuming as well. That's a ton of work. I know courts that have done, Judge Marsh did it on the salmon cases, he had expert scientific panels, and, so it's happened in some of the admin law cases, but it's a really big commitment. It'll slow down that's gonna take time. It'll slow down the judicial decision-making process, I think, if we go that direction.
Anybody else in the room? Okay, I'll go back to the online questions. How do you think the decision...
We've made the room so sad.
How do you think the decision impacts relying on a Skidmore deference? If so, how do you think that will change how the EPA justifies decisions?
Skidmore says you're supposed to give the agency, Skidmore has not been overruled, so it's still good law. Skidmore says you're supposed to give the agency a respectful consideration based on its expertise. So I don't, this is where I get back to the vibe test a little. If I'm a judge and if I trust what the agency's done, and I think the agency's done a good job, I could couch my ruling in terms of giving respectful consideration to the expertise of the agency. And if I think what the agency has done is stinky, I can use that same standard to say, well, I gave it respect, but it's stinky. So you get back to this vibe context, I think, for me.
And the decision does explicitly preserve application of Skidmore, so I think it's,
that's right.
It's there.
It's there, and so judges can use it, so. There's a question back there. Former student.
So when we're talking about changing the locus of decision making from one branch of government to another, it certainly seems like we're entering a period of potential upheaval here, right? Revisiting decisions that have been made and static for a long time, but to an extent, we face that process every time an administration changes too. So is there an argument to be made that after a period of upheaval, we would actually see more stability because of the permanence of judicial decision-making?
Is judicial decision-making permanent now? I don't know how I feel about stare decisis right now. I just want to make, I have one piece, I don't know if it's a response to this question, but I think it's just an important context. Agencies make thousands of decisions every day that political appointees and presidents and White Houses don't care about, right? Only some subset of those trickle up. all the student loan decisions that are made about the amount of student loans you are authorized to get, or, you know, all kinds of decisions, right? And so, I know that there's all this rhetoric about when you switch presidential administration, stuff is upheaved, but there's a lot of stuff that isn't, I guess. Government does persist at the career bureaucratic level. There is a steadying piece of that. And I worry that, particularly with Corner Post, a lot of that steadiness around regular stuff, you know, it's like the kind of stuff that we all realize the federal government does when there's a government shutdown, like all the parks closed and all the, you know, it's like the stuff that's not, it's not the meaning of jeopardy under the Endangered Species Act, you know? It's not the meaning of water to the United States, it's just how we function as a nation. And anyway, I don't know if that's part of that presidential transition. That's the hunting license dynamic that I'm worried about. That people who had sort of settled into the law being this way now may feel empowered to challenge it, and we go into we have that kind of upheaval. I don't know which is worse. You know, great question.
Looks like that's the time we have. Thank you all for being here.
So we have a 15-minute break now.
Break.